Hello, this is Kevin Thompson. I'd like to welcome you to the Davis McGrath LLC IP webinar series for October 3rd, 2012. Today's topic is the right of publicity. The recording and slides will be posted at the address shown on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our webinar mailing list. For those of you who need Illinois MCLE credit, if you haven't already done so, please send your name and ARDC number to me. And for those of you viewing the recording, please let me know how you watched the webinar as well and when you did so. As an announcement, the next webinar is coming up on November 14th, 2012 from 12 to 12:30 on the topic of photographers and copyright. And it's focused on specific issues related to copyright law that would apply to photographers. So today we're going for about 30 minutes and cover just what is the right of publicity, its origins, the basic elements, what happens to your rights after you die, some defenses that people may have to a right of publicity claim. We'll go through the highlights of the Illinois Act and talk about three current cases or scenarios that are in the news. So just what is the right of publicity? Well, the laws vary from state to state, but generally it is the inherent right of every human being to control the commercial use of his or her identity. And it's a very distinct right from those that we've talked about in prior webinars, such as trademark, copyright, or privacy. And it's also not just for celebrities. Every person has the right to control the commercial use of their identity. Now, an ordinary person may not have much in the way of damages, but still they at least can bring a claim. Its origins, it's an offshoot of what we would call the right to privacy, the right for the individual to be alone and not bothered, and you know, their individual information kept private. And it's an offshoot of that. The first case to really talk about it is the Heylin Laboratories versus Topps Chewing Gum case, in which it's a case involving the rights of a baseball player. Certain players had given one company exclusive rights for their images to appear on bubblegum cards, and this other company had decided to, induce these players to, have their images appear on there as well. And it's sort of the first case to really talk about, this right for a person to be able to control the use of their image on a particular commercial endorsement and actually use the term right of publicity. After that, there were lots of state laws. There was actually a big push in the 1970s and 1980s for different states to enact laws. Illinois did not have a statute until 1999. And then I should mention that there's the famous Supreme Court case. It's the only one to really address the right of publicity head-on, and that's the Zucchini versus Scripps Howard Broadcasting Corporation, in which Zucchini was a circus performer whose entire act was put on the news. He was a person that would shoot himself out of a cannon, and Zucchini was quite dismayed to see that his entire act, the actual act of shooting him out of the cannon only took 15 seconds of the entire performance. But that 15 seconds was what appeared on the news. And so he sued and won. It's a interesting case, and it's actually led to some of the exemptions that currently exist in the law, and we'll talk about that as well. So the basic elements, the plaintiff needs to own an enforceable right in the identity or persona of a human being, and has to prove that the defendant's use is likely to cause damage to the commercial value of that persona. And that's sort of in general the general basic elements. And the laws may vary from state to state. As I mentioned before, this is a creature of state law, and And so these are just the general basic elements. So when you talk about this person having an identifiable persona, that this use must be identifiable from the total context of the defendant's use. And such things that the courts will look at is, whether or not the name was used, whether or not there was a meaning given to this based on maybe dress or other things to show the identity. Look at the context. Why is this done here? Specific use of images. I mean, if it is the person's exact image, then it's clearly their persona. And also, there's lots of cases dealing with voice. There's certain cases where, like a person would not, Bette Midler, for example, would not agree to a commercial endorsement, so the company hired a voice actor to impersonate Bette Midler, and well, Bette Midler won that case. The next thing would be characters. Just because somebody portrayed a famous character in a movie or a television show does not automatically mean that the actor has a right of publicity. It mustn't be more than a mere reminder of the actor who played the role. But an actor can recover if the role becomes an integral part of the actor's persona. And the one case I'd point to is George Wendt, who was an actor who appeared in the television series Cheers, sued when the studio licensed the name Cheers to airport bars, and the company decided to put robots at the end of the bar that impersonated two of the characters, Cliff and Norm. And since one of the robots could be clearly identifiable as the Norm character, which Mr. Wendt played, his at the very least, his case, survived a motion for summary judgment. Now, these rights depends on the state law, can extend after death, and there's only 2 states that currently seem to not recognize a post-mortem right, which could be willed or transferred with the estate, and those 2 states are New York and Wisconsin. Illinois, for example, its statute allows rights for up to 50 years from the person's death. Which leads to several questions of conflicts of interest. It's sort of a fact question. In what state was a celebrity domiciled at the time of death? It's an important question. There is, was some controversy over whether or not Elvis was, a Vegas celebrity, or whether he was a Tennessee celebrity. But since Graceland was in Tennessee, Tennessee prevailed, and Tennessee actually has very strong right of publicity rights, I think mainly because of Elvis. And some jurisdictions, will weigh the interests of the states involved and look at a variety of factors, including what was this particular transaction. Did this one particular transaction occur in a particular state, and therefore that state has more of a right, to control its laws. Some other courts will apply like one state's right of publicity statute, but then for the rest of law, will apply their home jurisdiction's laws. But for the purpose of whether or not the person has a right of publicity, they'll apply that. And really, it's a matter of state by state application of these rules. And I did mention fame. Everyone has a right of publicity. It's not just a right for celebrities, but the extent of that fame goes to the degree of economic harm suffered. So if you infringe the rights of an individual who is not a famous celebrity, you certainly could be liable. And we'll talk about this when we get to the Illinois statute. The extent of their fame goes to the degree of economic harm suffered. There's certain defenses that came up that can come up. These are the first four that are most prevalent: copyright preemption, statute of limitations, the first sale doctrine, and also First Amendment and parody. We'll talk about each one of these in turn. I should mention that at any point, if somebody has a question, please feel free to do so. There is a method using the webinar software for you to ask a question. There will also be time at the end for questions as well. So copyright preemption, whether or not there's a conflict between the individual's right of publicity and the copyright owner's ability to exploit their copyright. And it generally comes down a lot with models and photographs that are taken of models. And a model release is something that a model will sign when the photographer takes the picture, and or should sign for if you were representing the copyright owner, and that photographer should get this release. Because then that they would have this bundle of rights that they can sell other than just the copyright in the image. And it should be noted that human identity is not copyrightable subject matter. So just because you take a picture of a person doesn't mean that you own a copyright in that person. All you have is a copyright in that photograph. And so somebody still could have right of publicity rights, and one of the cases we'll be talking about later comes out of those controversies. It's whether or not this right of publicity would preempt copyright law. For the most part, it doesn't. Statute of limitations, it varies from state to state. You could bring a case, you could have a case, but you brought it too late, and you could be barred. Illinois, in particular, allows 1 year from the date of publication. First sale doctrine is another one of these defenses. Like copyright, the first sale doctrine applies to the physical item as it's first sold, and the right of publicity does not apply to resale of certain items. So you may have rights that come with when things are first made, like for example a television show or something like that, but it would not apply to the resale or later syndication of that show. So if you're talking about that type of media, but if you're talking about books or covers of books, where an image might appear that might violate somebody's right of publicity, again, it's that physical item, and it does not apply to resale. First Amendment and parody. This happens a lot. Somebody might have a caricature or other parody of a celebrity. That could be protected by First Amendment, but this general principle comes out of these cases, which is that a depiction of a celebrity that's amounting to a little more than the appropriation of that celebrity's economic value are not protected expression. There's an interesting case that came out of this. I'm going to talk about this one briefly. ETW Corp. Versus Jera Pub Inc. ETW, that's Tiger Woods, and that's his corporation that controls his rights. And this covers this particular painting shown here of Tiger Woods playing golf at Augusta by Rick Rush. He calls it the Masters of Augusta. And it's not a like a photographic representation of what happened at Augusta. Actually, it's more very carefully placed and selected images of Tiger Woods that he believed had a more of a First Amendment type of issue, and the court balanced the free speech rights versus the right of publicity principles, and in this case Tiger Woods lost, and this particular painting was allowed to proceed to be sold. Now, if you do have a violation of the right of publicity, what are your remedies? Well, there are three major ones: injunctions, monetary relief, and attorney's fees. An injunction would be going into court to getting so the publication stopped. Monetary relief could be costs, could be actual damages. It really depends on the state as to what actually is allowed. And then attorney's fees, it depends on the state as well. Illinois statute, the right of publicity statute, can be found at 765 ILCS 1075/1, and it became effective on January 1st, 1999. And what it does is it does not affect the common law rights that people might have to right of publicity that affected before that date, but it does preempt any common law rights that would have taken place after that date. And it like the other states, it prohibits the use of identity for commercial purposes without permission. And it has a 1-year statute of limitations from first publication. It has certain exemptions that are in place, and a lot of these state laws have certain exemptions for things. It exempts use in media so long as the media is not itself an advertisement for goods or services, and it specifically exempts communicative and suggestive works such as an ordinary television show. An example here might be if you think that an aired television comedy invades your right of publicity because it's based on someone who could be identifiable as you, and everybody's laughing at that particular character, but it isn't expressly you. It's just identifiable, and it expressly exempts that particular work from right of publicity concerns. The Illinois statute allows for injunctions, actual damages, profits, and punitive damages. And so, that could add up a lot, especially if it's a wide ranging work. Or in the alternative, the person can elect $1,000 in damages. And I believe the purpose of this particular section is still to allow individuals to recover. The individuals who don't have a lot of actual damages profit can get this $1,000 in damages, and then still be awarded attorney's fees, costs, and expenses for getting the injunction that would prohibit further publication. So now we're going to talk about some current cases. Unless anybody has any questions at this point, we'll proceed to talk about them. The first one is a case that came out of the the Central District of California just this year. The Hebrew University of Jerusalem is the entity that owns the rights of Albert Einstein's estate. When he died, his scholarly papers and writings were willed to the Hebrew University of Jerusalem, and some other parts of his estate were willed to relatives. But the large portion of those rights went there. And in this case, General Motors put an ad together for their GMC terrain vehicle, which involved a digitally rendered composition of Albert Einstein's head put onto a model's body, and then the model has a tattoo of the famous equation E equals mc squared on his shoulder. So it's identifiably Einstein, but obviously digitally modified. The university sued General Motors for two essential counts. One was a violation of Einstein's right of publicity, and the second was on trademark grounds. They hold certain trademarks that they relate back to Einstein, and that they sort of a stretch for them that they tried to claim that Einstein's face was a trademark, and I should mention that in this case the court disagreed. But regarding the right of publicity claims, well, going through the elements, Einstein lived in New Jersey, and New Jersey does recognize a post-mortem right of publicity. There's no requirement that Einstein had actually exploited, this right during his own lifetime. Just because, he did not, seek commercial endorsements, during his lifetime, wouldn't bar, a later claim, after his death, for violation of that right. And so it would fall to his heirs, to bring this post-mortem right of action. But there was actually an interesting factual question, because the will that Einstein made, granted certain rights, such as his publishing rights to the university, but the rest of the estate passed down to certain relatives, including his stepdaughter. And so there's a question of fact as to whether or not, because at that point a right of publicity was not envisioned, whether or not he would have wanted his right of publicity to travel with his other intellectual property rights, which went to the Hebrew University, or whether they would have transferred by means of the residual clause of Einstein's will to his stepdaughter. And so the case was remanded for a determination of that particular grounds, or for further discussion, actually, because it's trial court level, and denies General Motors' motion for summary judgment on that grounds. So for further inquiry is needed. The other interesting point is that the court declined to comment on just how long the term of the right would be. As we've stated before, certain states have different terms. Illinois only allows the right of publicity for 50 years, and so if it was that type of a jurisdiction, the right of Einstein's estate would have passed by the time this was brought. But there are other states, such as Tennessee, which allow a 100-year right to go on, and so a further determination of that particular right still needs to be made, and so we'll see how this comes out. I certainly would imagine that this might motivate General Motors to settle, but you never know. Our next case comes from a long series of disputes that the Maryland Monroe estate has had with the Milton Greene archives. It should be noted that Milton Greene owns the copyright to certain famous photographs of Marilyn Monroe, in which she was photographed during her lifetime. And so they are trying to argue the difference between copyright and the right of publicity. And they brought this case in California. The Marilyn Monroe estate has been very active in advocating for a right of publicity that survives post-mortem in California. And they were certainly part of the group that got the law passed to allow, these post-mortem rights. But the state has run into a major problem in that for many, many, many years, it has argued that it was domiciled in New York for tax reasons. They wanted to avoid certain taxes that, would have hit the estate upon her death. California had a rather onerous provision regarding taxes, and so for many, many years it argued that it was domiciled in New York for tax reasons. And the important fact is that New York is one of the two states that's not currently recognized a post-mortem right of publicity. And in this case, the California Ninth Circuit held that the estate was stopped from arguing that it had a post-mortem right based on California law, because for many, many years it had taken the position that her domicile was New York, and they could not just for sheer economic purposes, make this argument that that it was all of a sudden now domiciled in California because they had a lot, lobbied for this law to be passed in California, whereas New York, does not allow that, and so the estate was stopped from bringing that argument, and that's a recent case that just came out the end of August, so we'll have to see what comes with that. But that's a Ninth Circuit decision, so I would certainly presume that might be the final word on this, but you never know. They could certainly try to appeal to the Supreme Court. We'll have to see what the Monroe estate decides to do. And then the final case I wanted to talk about, it's not a real legal dispute per se, but it is something that comes up. Is an example of how these rights have morphed over the years. And that was a digital recreation of Tupac Shakur, performed in concert. It was created by the company Digital Domain Media Group, and it was able to perform in concert with some of his former crew, Dr. Dre and Snoop Dogg. And the company that owns the rights to the Tupac estate is a company called CMG Worldwide. And CMG Worldwide is one of the largest companies to own the rights of publicity for especially for dead celebrities. They own a large number of celebrities' rights. They serve as a management company, and so the estates will often authorize CMG Worldwide to act in their behalf and negotiate deals, et cetera, et cetera. And so this is one of the new types of things. It was talked about as if it was a hologram, this particular representation of Tupac Shakur. It should be noted it isn't really a hologram. What it is really is it's a digital projection onto a screen or a scrim that the audience can't see. It's an application of an old magic trick from way back, in which case the projection goes onto the scrim, and other performers can be behind the scrim and still be seen by the audience, and it looks like the person is interacting with this digital representation. And interestingly enough, this was not a digital like compilation of old footage of Tupac Shakur. Instead, it is a 100% digital. It's essentially a digital model of Tupac Shakur that can be manipulated to perform, and it is not old footage. It's a very interesting application of this particular technology. We've seen dead celebrities interact in commercials by digitally substituting what the person was holding. I seem to recall that there were some commercials with Fred Astaire and so forth. He was dancing with the vacuum cleaner. And there's been lots of other types of product endorsements that have appeared essentially by using old footage and inserting a new product into that old footage. But this is this technology really opens up the rights of an estate for further commercial exploitation. And we'll have to see how this turns out. This particular application was done for a series of concerts. There've been discussions of taking this concert series on the road. and perhaps we'll see more celebrities be digitally resurrected as this proceeds. And I think that we probably will also see there is a sort of a movement to allow for digital reconstruction of actors. So we might have a living actor that is digitally composited into a film, and so we might an actor might be scanned, and their digital representation taken, and enough performance capture is taken such that that particular actor might be reproduced completely digitally. You wouldn't need an actor using some of those if you've seen motion capture used in modern films, where they put on a special suit with these tennis ball like the things that are tracked with lasers to track their movements. These things could be completely digitized, and so we'll have to see what happens with that. I seem to recall some in interviews with celebrities, talking about these particular applications, and we'll have to see how that turns out, and whether or not that actually comes to pass. So that's sort of the far-ranging aspects of the right of publicity, and how they affect us today here in our modern society. So it's a good point to see whether or not anybody has any questions. As a reminder, the software allows you to put in questions, and for those of you watching the recording, you can always email me your question at the address on your screen. We'll pause here. Oh, looks like there is a question. The first question is, what do you think about right of publicity concerns when somebody takes a picture and incorporates that picture into a report for a client when the picture includes people in the background? For example, a picture of an office lobby with people, such as non-famous people walking around, being incorporated into the report. That certainly can raise right of publicity concerns. For the most part, it's prudent to take the position that every person appearing in the photograph should have their right of publicity waived, such that more of a controlled set. But that's not always possible, especially for uses such as crowd scenes and so forth, it certainly would be prudent if possible, but it certainly is an issue, and it's very fact specific, so it's hard to say for sure what the person should do. But in your particular hypothetical, that if the persons are readily identifiable, a prudent approach might be to blur them out, or to otherwise make them unidentifiable if possible. The next question is, are the courts adapting to new tech, such as what you mentioned in the Tupac case? I'm not aware of any of these new cases being tested in court. The Tupac case is one where it was done with the full authority of the rights holder. It was a fully authorized representation of Tupac that was created, so there won't be any legal questions for that particular application of it. But it wouldn't be impossible to imagine a case where someone does this for someone else, and they did not have those rights. And we'll have to see. I mean, I think it would be a fairly straightforward application of the right of publicity, if that should occur. Are there any further questions? Well, if anybody has questions later on, feel free to email me or call me, and I will certainly be willing to address that. Thank everybody for attending. Our next webinar, again, as a reminder, is coming up on November 14th on the topic of photographers and copyright. For those of you who need Illinois MCLE credit and haven't already done so, please provide me with your name and ARDC number. And again, for those of you watching the recording, please send me your name and ARDC number and when you viewed the recording. And I'd like to thank everybody for attending. Have a great day.